Okay, there at the end, I thought somebody talked about 209, and I was like, wait, what? I don't, 209 hasn't even been mentioned in our recent conversations. So my question, what is exhibit 2041 that supposedly is identical to exhibit 211? What is that?
That is a NSF audit.
So that is not one of the,
That's not one of the.
not one of the testing things, right?
Correct.
Okay,
Yeah,
okay,
we can push that aside.
okay. And both versions of that NSF audit are now admitted, even if they're identical. Okay. I mean, I just have to make a decision. I know both sides have probably told me their points already, but
Judge, I've had a chance to look at the first document. There's an even more serious problem. This is direct violation of motion eliminated because it is a state certification. This is a state certification dated on November 18th.
so which exhibit are you talking
We're
about?
talking about the very first one, which is 2059. So they're trying to introduce a state certification that the state of Nevada says this is the testing you're supposed to do, and they've done it all. So it's a direct violation of the motion eliminated. They didn't bring that up, Your Honor.
Preliminary response.
This is for a lab. This is not any governmental compliance.
So somebody pull it up for me, because I'm up here blind, I don't have it in front of me.
And it's also part of Blaine Jones' testimony that's going to be played later, either to, well, probably not today, but.
So this is,
If you scroll down, Your Honor, you'll see that they call this following the cover page are state certification list. And then they have the states listed, and that includes the state of Nevada. Right there, Your Honor.
go ahead. Yeah, scroll down a little
Just that they're certified by the state to perform lab testing.
bit. And the next page probably is the one that says, oh wait, was Nevada on that other page and I just didn't see it?
Right there, the third on the right, third right, above New Hampshire, right there.
Oh, okay, I did. I was looking at the left column. No. So remind me what the protocol on exhibits is.
The protocol was that, at least as of yesterday, they should have given us a list of exhibits that they wanted to use for this witness, an entire list. They didn't give us one single exhibit. And assuming they violated that, they should have at least handed us the documents this morning that we're going to go over, and especially unadmitted exhibits they should have shown us. So instead, they gone through this witness's testimony for 45 minutes using the admitted testing exhibit, and now they try to spring 3 exhibits, one of which violates the motion eliminated. I haven't even had a chance to look at the third exhibit, Your Honor. So
Any response to that? I'm particularly interested because we haven't talked about so much the protocol.
Well, yeah, I've already admitted that I did not realize that these 3 additional hadn't been pre-admitted. One of them is actually plaintiff's document plaintiff produced. The other one is the subject of testimony for Blaine Jones that's going to be played later on regarding the annual testing. But really, Your Honor, at this point, I'll be satisfied with however you rule. And as far as, just the last point, as far as the state certification, that only goes to the lab being certified to do lab work in those states, has nothing to do with real water or state requirements or regulations.
There is another section of that that says that the tests are accredited by the state, including that.
It just means the tests are approved, Will.
So so to be fair, from what little I've seen, which is, admittedly just a page, what I've seen on that doesn't concern me so much, because, it shows, that every state has approved this testing and accompanying certification number. I don't think shows what point is saying it does. But so, unfortunate, I mean, had there been an opportunity to go over, ahead of time, who knows, maybe they would have stipulated to admit it, but you put him and you put me in by him, this kind of awkward position. We don't have somebody, presumably it's authentic, but to lay other foundation for it. And not giving the opportunity to prepare, even as of this morning. So I'm gonna deny or uphold the objection, I guess is a better way to say it. On 2059, 2110, 2217. Had this been, we have a huge list of pre-admitted, and we all have been able to work out a lot. It's unfortunate here that kind of sprung on us mid-testimony, so sorry.
Understood, Your Honor.
There's the third one was 2059. We didn't.
Oh, yeah, did I say, so objections upheld on 2059, 2110, 2217.
Please be seated.
Welcome back, ladies and gentlemen. Thank you for your service and for your patience. Very much appreciate both. Mr. Freeman, go ahead.
Thank you, Your Honor. Ms. Olsen, can you hear me?
Yes, I can. Can you hear me okay?
Yeah, I can hear you loud and clear. Okay, we left off, we were talking about the lab testing results and testing annual, weekly that was done by Real Water.
Yes.
And the testing that was done, was it to their, the final water product that Real Water made?
That is my understanding, yes.
Did they also do testing of the E2 concentrate?
I believe I did review analytical results that indicated that the testing was done on that concentrate, yes.
Do you know how hydrazine got into the Real Water?
I do not.
In over 2 decades of experience in wetlands, environmental consulting, and the bottled water industry, have you ever seen anything like this?
No, I have not.
Okay. Have all your opinions you offered today been to a reasonable degree of scientific probability?
Yes, they have.
Thank you very much.
Nick
Yeah.
Ross.
Yes, Your Honor.
Okay.
Afternoon, ladies and gentlemen.
Afternoon.
Good afternoon, Ms. Olsen. Can you see me? This is Will Kemp. Can you see
Yes,
me?
I can, Mr. Kemp.
How are you today?
I'm okay, thank you. How are you?
Good. And you mentioned HACCP, right?
Yes, I did.
Is it critical in a bottled water facility to have a strong HACCP program?
It is important to have a HACCP program in place, yes.
Okay, and it's also important to have strong quality assurance programming in place?
Yes, the quality assurance program would be part of your HACCP program, yes.
Have you looked at Dr. Hutt's trial testimony in this case?
I have.
And would you agree that Real Water had a poor or non-existent quality assurance program?
I do not necessarily agree with that statement, no.
Okay. And did you review the testimony from Patty Converse that she had no quality assurance training and she wasn't qualified?
I did not review that testimony, no.
Okay, can you show that to her, please?
Now, when you got hired, you said you were hired to be the receptionist, and then a month later, you became the director of quality control.
Do you find that problematic, Ms. Olson, that the receptionist was promoted so quickly to be the director of quality control?
It would, without having additional information, it's difficult for me to qualify that. As to
Not a
whether or
good
not
thing.
she had
Not a
the
good
training in
thing.
that timeframe.
Not a good thing to make the receptionist to the director of quality control, is it?
It would depend on the circumstances.
They gave her no training, not a good thing?
If she did not have the proper training, she may not have been adequately suited for that position.
And would I be correct that the director of quality control or someone in the quality control department is the person that usually gets customer complaints?
Not always. It would depend on how those responsibilities are defined at the company within their standard operating procedures or HACCP plan or other programs to direct where customer complaints would go.
Okay, I didn't say not always, I said usually it goes to the quality assurance department, right?
No, not, I'm responding and saying not always.
In this case, the quality assurance director never saw a customer complaint, did she?
I do not know that, if that is fact or not.
Okay, Shane, can I show the next one, please? No, not the complaint, the next part of the Converse's testimony, please.
First of all, I assume all the customer alert forms were filed in one big place, right?
I would think so. I never saw them.
Okay, you're the director of quality assurance.
Right.
Was this a violation of basic food safety principles, ma'am?
Again, this is not anything that was in my scope of review specifically, so with only hearing snippets of information, I cannot qualify that and make a judgment to that regard.
So before you came here to testify today, you didn't look at Ms. Converse's deposition?
No, that was not within my scope of review for what I was engaged for.
So your scope of review was not to tell the jury one way or the other whether they had a good HACCP program? That was not your scope of review?
No, it was not.
And the scope of your review was not to tell the jury one way or the other whether they had good quality control?
No, it is not.
Would you agree with me that the quality control director should at least be told that he's the quality control director?
To restate your question, Mr. Kemp, if the quality control director is given that position, yes, they should be informed that that is the position that they are in and their responsibilities in that position.
And did you look at Mr. Desautel's trial testimony that he was a fake quality control director? He wasn't told he was quality control director?
No, I did not.
Shane, can I see that, please?
All right, did they call you Director of Quality Assurance?
Yes, they did call me that.
Okay. Were you really the Director of Quality Assurance?
No, I was not.
What were you?
I was a supervisor.
And you've never been involved in quality control before working for Real Water?
No, I have not.
And no training with regards to quality control?
No, I have not.
Okay, would that be a HACCP or quality control violation, holding someone out to be the quality control director and not telling them about it?
It would be a misrepresentation to the employee and to the facts of the company operating standards if you're calling somebody the quality control director and not informing them that that is the title you have given them.
Okay, and I think you told council that because of the NSF re-audit, that there was no problem with HACCP at Real Water. Is that what you said?
I did not say that there was no problem. I said that based on the comments made by the auditor, they had completed corrective actions for their HACCP program.
Okay, were you aware that Mr. Desitel testified that there was no HACCP at Real Water?
I am not aware of that, no, I did not review his testimony.
Could you
That was
play-
outside of my scope of engagement.
Could you play that for me, Shane?
And did Real Water have a HACCP program?
No, they did not.
Okay. If this is true, would you agree with me that Real Water was violating the fundamental principle of food safety?
If it were true, but I do not have the facts to back up that statement as to whether or not it is true. I only reviewed the documents that I have stated that I have reviewed. I have never reviewed any further documentation.
Okay. And if there were no procedures at Real Water, that would also violate fundamental tenets of food safety, would it not?
Can I ask you to please clarify what types of procedures you're referring to?
Well, let Desitel, please play Desitel and he can clarify that for me.
Excellent. Did they have operating procedures?
No, sir.
Operating procedures, ma'am. If they didn't have operating procedures, that'd be a fundamental violation of basic food safety.
If they were in fact did not have standard operating procedures, then they would not be adhering to the principles of the HACCP program. That would be correct. However, I do recall seeing documentation that Real Water did have standard operating procedures, written policies.
Okay, isn't it true that the FDA found exactly the opposite when they did the inspection facility report?
I do not recall exactly how the FDA worded that in their inspection.
Well, let's take a look at it, Shane. Can I have that, please? It's Exhibit 3. Okay, you did not have a written food safety plan. That's a violation of basic principles of food safety, right?
That would be in violation of the FDA requirements for a food safety plan under, as they state, the 21 CFR Part 129,
Okay.
which is the Food Safety Modernization Act requirements.
In point 2, the hazard analysis didn't identify a known or reasonably foreseeable harm required to prevent control. That would also be a violation of fundamental food safety principles.
It would be exactly as it's stated. They're not typically classified as violations.
Okay. And then you talked a little bit about process controls and direct. It says here the process controls are not validated. Do you see that?
I do see that.
They didn't have records. You didn't see that?
I do see that.
Okay. And I think you told the jury what a great job they did with all this bacterial and metals testing. You recall all that testimony?
I do not recall stating it was a great job. I simply stated the fact that they had performed the testing based on what I had reviewed
Well, what
in
did the-
accordance with applicable requirements.
What did the FDA find on point 9 there? Can you see that?
They
ma'am?
found that based on their review, they did not perform it at least once per week.
Is this the first time you've seen this document?
I have seen it before, however, I did not commit each identifying point to memory.
Okay, let's move over to the GCMS testing. First of all, let's show a picture of the GCMS machine, make sure we're talking about the same thing. Okay. Okay, that's a GCMS machine, right, ma'am?
That I am familiar with, yes,
And you're familiar with it because you used it in college 20 years ago, right?
that is correct. An older model, but similar, yes.
And that's usually used to do what's called non-targeted or screening tests, is that right?
They are also used for targeted tests under specific methodology.
Okay, but generally they're used for non-targeted tests, right?
No, actually, it's used for both.
Can you explain the difference to the jury between a targeted test and a non-targeted test?
So a targeted test using the GCMS is to look for a specific chemical parameter, and the GCMS is typically used for volatile organic compounds or semi-volatile organic compounds, volatile meaning ones that can gas off of a substance. Non-targeted would be the library search, which I am sure that you have already heard in other testimony, meaning that you are running it through the GCMS, meaning the sample, and then comparing basically the printout that's provided by the GCMS. It gives you spikes that show the different potential. It's basically the carbon chains that are shown of what's in there, and it compares it to known substances, and then you match it up in that known library of compounds to determine what the compound is within a given percentage accuracy.
Okay. Let's see if we can agree on the key facts here. Shane, can I have the next slide, please? So, point number 1, you agree with that, right?
I don't know that it would classify it as a standard GCMS test. It would be because you would write it on your chain of custody for a lab test that you are requesting a volatile organics library search.
Okay. And what did this cost? $100, $200?
The cost is fairly low. That's a good representation.
Okay. All right. And there's hundreds, if not thousands, of laboratories in the United States that can do this?
I would classify it in the hundreds. There's far fewer laboratories now than there were prior to the pandemic.
Okay, and Real Water never did a non-targeted screening test or a non-targeted GCMS test, more specifically, did they?
To the best of my knowledge, based on documentation I reviewed, no, they did not.
Okay, did you look at Mr. Marlowe's trial testimony?
No,
You know who he is?
I do not.
He's the inventor of the product. That help?
The inventor of
The
which
Real Water
product?
product. The
The
concentrate.
titanium tubes?
Yeah, the concentrate.
Oh, okay, the concentrate, okay.
Okay? And he said that Real Water should have done a general test to look for toxins. You're not aware of that?
No, again, that is outside of my scope of engagement.
Okay. And the FDA used a GCMS machine. They did non-targeted screening on the concentrate, and they found hydrazine in all 3 samples, right?
That is my recollection. They did other testing as well, not just the non-targeted test. They went through a series of tests to determine the substance, and some of them were targeted tests to start with.
Okay, so the big issue in this case is should Real Water have done the non-targeted screening test at the outset, or should it not have done that? That's the big issue, right?
Per your statement,
Well, that's the
That
issue
is-
you were assigned to take a look at, right?
I was assigned to determine whether or not hydrazine is a required compound or a listed compound in applicable list of testing standards that Real Water is held to.
Okay, well, I thought you gave an opinion, and I can read it word for word for you, but in general, you said it was your opinion that you do the non-targeted GCMS only when you have reason to suspect an unknown substance. That's your opinion, right?
That is correct, yes.
Okay, so only if you think there's a potential problem, you're supposed to do that. That's your opinion, right?
When you have reason to believe that there is an unknown substance or issue, that may be a methodology that you would use to determine what that substance is.
And wasn't there a specific reason to believe that in this case from the get-go?
Not that I'm aware of, no.
Okay, are you aware that they were electrifying the water for 10 to 12 hours, 2 different times, when they were making the concentrate? Are you aware of that?
I have not reviewed details of their process, no. That was outside of my scope.
Okay, so you weren't aware of that?
No.
Okay, and Dr. Hutt said, and I think others that we'll get to, said that when they're using this, what I would call a bizarre manufacturing process, that should have led you to do non-targeted testing. Do you agree with Dr. Hutt, or do you disagree with Dr. Hutt?
That is Dr. Hutt's opinion.
Okay, and to be fair, let me show you exactly what Dr. Hutt said. Shane?
And do you have a view as to whether or not, when you're bringing out a new product, like this new water product, they should have used this machine to test?
Well, two things, yes. As I mentioned, it is a regulatory requirement that there be an annual test for contaminants, environmental contaminants, but then also in just screening a product that has a very complicated chemistry process involved in its manufacture, which is real water. I mean, you're adding and deleting electrons from water to change the pH of natural water. It's a chemical process, a very complicated one in its elemental chemistry. So you have lots of things that can go wrong. And it is an opportunity to really find them before they become problems by using such screening technology as GCMS.
Okay, now that Dr. Hutt's laid it out, do you agree with that?
Again, that is her opinion.
I'm asking your opinion.
I do not share that same opinion as I have offered in previous statements.
Okay, isn't it true that other bottled water experts have explicitly stated that because of this electrolysis process, that Real Water should have done non-targeted screening? Isn't that true?
My recollection is that, yes, Mr. Heidel has offered that opinion.
Great. So tell the jury who Mr. Heidel is.
Mr. Heidel is another industry expert in the bottled water industry.
Another industry expert. Okay, you told the jury there was a very prominent water bottling association founded in 1980, did you not?
I did,
Who
yes.
founded that?
Mr. Heidel and others were members of the original executive committee that founded the International Bottled Water Association.
So Mr. Heidel was the founder of the International Bottled Water Association, right?
One of the founders, yes.
And you told the jury you were very proud that you were on the board of directors for the last 3 years of this exact same association, right?
Yes, I am a member, yes, and proud to be a member.
And not only did Mr. Hydell found that particular association, he's founded other bottled water associations. The International Association, the Asian Association, other bottled water associations, correct?
I don't recall exactly all the ones that he's considered a founding member, but I would believe that is likely true.
Okay, and he's considered, I don't know how you want to call it, the godfather, the Yoda, the leading figure in the bottled water industry. Would I be correct?
He is a leading figure. He's been in the industry for quite a long time.
He is the leading figure, is he not?
I would not, that's not a term that I give him or that others all necessarily give him. No, you're actually the first person I've ever heard use that term.
Okay, and he's been your mentor over the years?
He is someone that I do genuinely look up to, yes.
And he says that because of this electrolysis process, real water should have done the non-targeted GCMS. That's his opinion, right?
That is his opinion.
And that's Dr. Hutt's opinion, right? You just heard
Yes, that is.
it. And that's still not your opinion, or you don't have an opinion, or where do you want to leave it with the jury?
That is not my opinion. However, my experiences and those that I work with in the bottled water industry are, I would classify them as different than those that Dr. Hutt and Mr. Hydell have worked with.
And what's the downside to spending the $100 or $200 and doing this non-targeted screening test? What's the downside to actually knowing what's in the product you're selling? Is it the money?
I do not believe that cost has any bearing or any factor in it whatsoever.
Too much
But
trouble?
again,
Too much
it's not
trouble?
a test that you would think to run or, plan to run unless you had reason to believe that there was an issue or some other contaminant source. Real Water was using an approved and tested public water supply going into their water. They themselves were utilizing other steps in their own process that a bottler would typically use to ensure a safe product. Yes, I realize they were using an innovative technology. However, there's also not a requirement beyond the analytical testing that I've already testified to under federal statutes that require them to do anything more than that. So it is not something that they would do.
Stop,
And
please.
that's my opinion.
Ma'am, please, Judge, I move to strike that last comment.
Yeah, so the jury will disregard that last portion of the answer there. You've answered his question. If you have another one, go ahead, Mr. Kemp.
You said innovative process. You're talking about putting it through the titanium tubes for 10 to 12 hours and shocking it, not once but twice. That's the innovative process, right?
That is correct.
And Mr. Hydell and Dr. Hutt both say that because they're doing this, they should know there's a potential problem with the chemistry and they should do the non-target screening test, right?
That is their opinion.
Here, let me try it another way. If you knew a brand new bottling water facility was being set up somewhere and they were using this exact same methodology, this titanium tube and the shocking for 10 to 12 hours, wouldn't you tell them to do the non-targeted GCMS screening test?
Based on what we know now from this case, then yes, I would in that specific instance.
Okay, so you think Real Water should have spent the $100, $200, that other people that just say take spring water and put it in bottles, they shouldn't do it. Is that what you're telling me?
I believe that you have to look at all of the data, the entire situation, the process, and the reasonable likelihoods and scientific information as to whether or not you believe that the testing that you are doing is providing you all of the information that you need. or whether additional testing is needed.
And so you don't want to just waste the $100, $200 to do the non-target screening. That's what you're telling us?
No, again, I already stated that I do not believe that cost is a factor. The annual testing cost alone, just that annual test parameters, that's generally upwards of $2,500. So I don't believe that cost is a factor. I believe that you are looking at whether or not it is, something that you have reason to believe that you should be using and analyzing for.
Okay, reason to believe. After all the customer complaints started coming in, you've seen the one about the gasoline-like substance, the chemical smell, all these other complaints. You've seen these all, right?
I have seen various of the customer complaints, yes.
Okay, can I have my complaint tree changed, try to go quicker? Yeah, Judge, I'm trying to get this thing. Sure. Okay, put all the complaints on there, Shane. Let's jump right to it. So after getting all these complaints, man, including the...
Objection, Your Honor, you haven't seen this.
Yeah, take that down.
This is a...
Yeah, come on.
Let's try to get you out of here. Okay, back up the complaint, please. Shane? So after all these complaints came in, including the 2018 one about Mr. Watkins being in the hospital for 2 weeks, you think at this time Real Water had a reason to do some non-targeted screening testing?
So looking at this, I don't recall some of the, like each and every one of these, but I believe that you need to take each one and look at them and look at each circumstance. And I know that in some of them that I recall reviewing, again, I reviewed these just as more of an aside. This was not part of my scope of engagement. But in looking at some of them that I recall reviewing, Real Water did complete, an investigation where they, looked at their retained sample or obtained other bottles of the same lot from the location where original ones were purchased, and did not find, additional evidence to move forward. So with just looking at this, I don't know if they would, if they should have proceeded with some sort of additional testing at that time, because I've definitely not reviewed every one of these dates or persons that is listed on your matrix here, sir.
Yes, Shane, can I have, let's fast forward, and let's add another 15 complaints onto this tree, okay? Shane, can I have the October 15th? Ma'am, this is a document that Real Water gave to the FDA in answering questions. So here we are on October 15th. They have numerous complaints by customers. And you can read as well as I can, 25 to 30 calls. This is in addition to those 15 I had on the complaint tree. So you think at this point in time, Real Water should have done some non-targeted GCMS testing, right?
So let me first state that again, this review of the complaints and the information provided therein is beyond the scope of my engagement. So I have not reviewed all of this information beforehand. But looking at what you present on the screen, Mr. Kemp, some form of testing was likely appropriate. If that is non-targeted testing, it may have come to that point. There's typically I'll call it a due course of action, at least in my experience as an environmental consultant, in someone that follows due process. And it's similar to how the FDA laid out their testing. They didn't jump immediately to the non-targeted. If you look at their report, they went through I'll call it most likely contaminants first that may sicken people, such as bacteriologicals or fungal spores or things like that, or some other like I'll call known toxins first, and then went to non-targeted testing. So it may be a process of elimination, essentially, by which you may do testing when you've received a numerous group of complaints on any food product.
Okay, so you agree that on October 15th, they should have started doing some sort of testing, some sort of detailed investigation, correct?
I would agree with that statement, yes, that
And
an
how about,
investigation, in my opinion, should have been.
and last question, how about a recall? They should have done that on October 15th also?
Based on their findings and that evidence, they should have likely consulted with, the FDA and or the state, I believe it's a health department in Nevada. And I, notified them, that's typically the procedure, and then discussed, the level of, potential recall of the product and what that would look like. I mean, that would be my recommendation if I had been consulting them.
So
Yes.
if you had been consulting them on October 15th, you would have recommended that they consider a recall, correct?
Objection
Well,
beyond the
to
scope.
discuss what that is, that's typically how those go. You talk to, the applicable authorities, to coordinate that effort,
Okay, and that's what you would have recommended.
yes.
Thank you.
Any rebate right?
Yes, briefly, Your Honor.
Sure.
Hello, Ms. Olsen. Eric Freeman again.
Hello.
Couple questions. Now, you testified about reviewing NSF audits going all the way back to 2014, is that right?
That is correct.
Okay, and all those audits included an audit of the Real Waters HACCP program?
That is correct.
Okay, and without going through each of those, you looked at the scores that they were given for their HACCP section of the audit, is that correct?
That is correct.
Would they have gotten those scores if they didn't have a HACCP or quality control program?
Your Honor, that's speculative audit, Judge.
Say that again.
It's speculative, it's outside
Oh,
scope of
overruled.
it's outside scope of fraud.
Okay,
Did she answer the question?
oh,
I don't know that she did.
Did you answer the question? I'm sorry.
I did not. I was waiting for
Yeah.
Judge Harvey to.
You could answer if you remember the question.
Eric, are you able to repeat the question?
Yeah, my question was, after reviewing the HACCP scores they received from all the audits from 2014 and on, would they have gotten those scores if they didn't have a HACCP program or quality control program?
For the ones that I recall where there was I'll call it a more positive result, on their score within the HACCP category, meaning, they may have had some auditor feedback, but if they had not had any sort of a program or documents in place, then no, they would not have received that score. And the auditor comments lend to that, specifically. They commented that they reviewed specific documents within the HACCP program.
Okay, and you heard testimony that was played back that Real Water did not have any standard operating procedures. Would that have been noted in the audits?
Yes, it would have under various of the categories. Those are documents that would be reviewed to meet those criteria.
And did you see anywhere noted that the auditor found no standard operating procedures?
I did not. In fact, and unfortunately, I don't recall exactly which one or two audits it was, but I do recall auditor notes that actually indicated standard operating procedure numbers that they reviewed to document the evidence that they reviewed to meet the specific criteria.
Okay. Now, your scope was to review the audits, the corrective action taken, and the water testing in this case, is that right?
That is correct.
In examining the audits over the years, did you find that Real Water was trying to make improvements from audit to audit?
When I review them sequentially and the auditor notes therein in each one, yes. It appears to me, based on that information, that they were trying to make improvements
And,
in each report.
okay, not to go over all the testing we talked about earlier, but the testing that Real Water did, is that appropriate for a bottled water company?
Yes, it is.
All right, and Mr. Kemp brought up Mr. Haddell about non-targeted testing. Do you recall that?
Yes, I do.
Okay, and I believe that you disagreed with Mr. Haddell's opinion that it was necessary for bottled water companies?
I do disagree as a general approach, yes.
Okay, and your colleagues in the International Bottled Water Association, is that right?
That is correct.
Okay. Does the International Bottled Water Association recommend non-targeted GPS testing for bottled water?
They do not recommend it, no.
Okay, so would you say the IBWA shares your opinion on the testing?
I would just simply state, so I'm not stating anybody else's opinion, but I would state within the IBWA's code of practice for members, they do not require non-targeted testing.
Okay, thank you. And again, once more, have all of your opinions here today been to a reasonable degree of scientific probability?
Yes, they have.
Thank you very much.
Thank you.
No, Judge, I think we all have enough traffic already.
Any questions for me? No? Okay. Thank you. Okay to break for the day?
Yes, Your Honor.
That's right.
Okay. So ladies and gentlemen, we'll break for the day. Come back tomorrow at 11 a.m. 11 a.m. During this recess, you're admonished not to talk or converse amongst yourselves or with anyone else on the subject connected with this trial. Do not read, watch, or listen to any report of or commentary in the trial or any person connected with this trial by any medium of information, including without limitation proof. Social media, text, newspapers, television, internet, and radio do not visit the scene of any events mentioned during the trial. Do not undertake any investigation. Do not do any personal communications on these social networks and sites. Do not do any independent research, including internet searches. Do not form or express any opinion on any subject connected with the trial until the case file is submitted to you. See you back tomorrow at 11 a.m.
Please rise for the jury.
Okay, so tomorrow, what's the plan?
Judge, I'm thinking they're gonna get their case tomorrow. I'm hopeful that.
So that question's probably more for their side.
Your Honor, we have one live witness coming in the morning. He'll probably take until early in the afternoon, and then we have a couple items like maybe hour and a half, 2 hours worth of video depositions to play. I believe that'll eat up most of the day long enough that we'll be able to rest for the evening. And then I think I talked to Mr. Kemp a little bit, and it seemed to be, we were planning on doing the closings on Wednesday, right, Will?
Yes, Your Honor.
Okay.
The only thing we have to get done is jury instructions, the verdict form.
Yep. That's why Ms. Rivera, Caitlin.
Right, so we have sent our proposed verdict form to defense, and we've also sent our comments on the jury instructions. I think there's some minor differences there.
Yeah, so, on the jury instructions, we got the red line. Well, we got a lot, most agreed to, which is helpful, so thank you all. Bear with me a second. So we got two competing punitive ones. Yeah, so, and then, the red line disputed jury instructions, compensatory phase.
Your Honor, can I inquire if that's the set we provided at the calendar call?
Yes, it was when Ms. Switzer sent right after, I think right after trial started or something like that.
Yes, Your Honor. So over the weekend, as you requested on Friday, I went through those instructions and made some red line changes to the set, highlighted the ones that are disputed, the red line changes based on the intervening events that happened over the course of the trial, and sent that to Real Waters Council. We also sent our proposed verdict form. Understandably, they were preparing the witnesses for today, and I wasn't able to send it till late last night. Worst case scenario, the disputes aren't that many. What I would suggest is probably give them the opportunity to review the red line changes I made last night, and so we could try to narrow them to hopefully nothing. But if there are any outstanding, we can address them tomorrow, and I'll make sure the court has the most up-to-date set after we've met and conferred.
So, no, thank you. And anything from the defense?
Yes, Your Honor, very quickly, Mr. Pepperman's right. I did start reviewing them today. I agree with Mr. Pepperman. I think we'll, at least on compensatory instructions, I believe we'll be able to reach an agreement. We may need the court to rule on the punitive because this case is an interesting and unique situation. But I agree with Mr. Pepperman. I think if him and I can sit down tomorrow, we can probably figure out.
So we'll need to finalize tomorrow, it sounds like, right? So, yeah, make sure, you take advantage of tonight, I guess. Let me, one question I had that here's some things I saw, and if they're already addressed, great. If not, keep these in mind. Again, not very many, so yeah, thank you all. So, current caption popped into my mind, because one of the ones is on the plaintiff says just real water, plain, real water, and then defend, this is just on my page 12 of the red line that this popped up, that plaintiff has a proposed strict liability instruction that just simply refers to real water. Defendant, and it's rebuttal, its proposed one says Defendants, AffinityLifestyles.com, Inc. and Real Water, Inc. have admitted real water was defective. So caption, if caption's finalized, great. We've got a stupid order waiting for me to say. What does it say in there? Anybody?
It's actually.
I just removed the other co-defendants from the caption.
Oh.
If I'm assuming you're looking at the right one, it just leaves Real Water or AffinityLifestyles.com and Real Water Inc. as the only two defendants on the caption.
Okay, so if we have technically the two entities, at some point in the jury instructions, you probably, because all they've heard is real water, real water, real water. They probably really won't understand what AffinityLifestyles.com Inc. is. So you may want to define, defendants as real water.
Your Honor, I think that's a great suggestion, and we actually have accounted for that. It's in the agreed upon set. We call Affinity and Real Water collectively Real Water in the instructions and verdict form right at the front. I think what you're referring to is in that version of the disputed ones, that's one that we kind of disagreed on, and Real Water submitted their own. But the one that's actually agreed upon in red we'll just say real water, not definitive lifestyle and real water.
No, and that's, like I said, that just was something that popped up and that you've already addressed, great. The other kind of general, and maybe you've addressed this too, it is, you know, we have potentially past pain and suffering type of damages, future pain and suffering type of damages. If there's any future medical special damages. Another disputed one went to mental anguish. Maybe I need to rule on that if you can't agree, because that was like the bystander one, I think. But I've done enough talking. Anything else we need to talk about other than, I mean, we'll have to finalize this one.
Yes, sir, I'll just comment that we're aware of the issues that you flagged, Your Honor, and those are things that we're specifically discussing, and how to handle it, and so I think we're all on the same page in terms of those, and they'll be ready by tomorrow afternoon.
Agreed.
All right, we'll see you tomorrow, Odou.
Thank you very much.
Thank you.